Right, good afternoon everybody. It's just about afternoon, isn't it? Welcome to this session. This is the breakout session on problematic consumer markets and the way forward to more effective enforcement and redress. We're going to try and think about each of those aspects. I'm going to be facilitating this discussion with my colleague Nijole Zemaitaitis, and we together are going to try to make sure the discussion keeps moving. We do want to make sure that we have full participation from people, from all of you, because that will, we think, lead to a better set of conclusions. But we want to try to get some very concrete conclusions, something which we can, you can write down and say, look, this is, we think, a good idea. This would be a good way forwards for the European system in consumer markets. Now, in the seating here, there's people seated kind of all over the place. It's a matter for you, of course, but if you're sitting in the wings, you may prefer to move to sit at the front here in these two sections. But of course, I'm not going to force you to move, but an invitation really, because you're kind of all over there and it's a bit it's less intimate. Anyway, I'm going to hand over to my colleague who's going to introduce the rest of the session. Thank you.
Okay, so we've had a lot of mention during the conference about some of the areas that may be causing problems, such as comparison websites, geo-blocking, the sharing economy. So what we want to have you thinking as the speakers are talking, because we have three very interesting speakers, we want you to think about, are there any other areas that we haven't as yet identified? I mean, what about these review websites? What about the whole issue of things like cloud storage? Who's responsible? How do you make sure that all of your precious documents aren't sent off into the void somewhere? How do you get them back? So we'd like you to sort of think, as you're listening to the speakers, about those sort of areas. And secondly, has enforcement kept up with these new challenges, or is there a need for new powers or some different powers? If so, what should they look like? I mean, for example, do we need stronger investigative powers to get information, for example, to take down fraudulent websites? And thirdly, everyone seems to agree that redress is essential, and particularly access to redress and people knowing about redress. But perhaps as importantly, does it deliver what people want? So when you get to your redress, when you've actually managed to find it, how satisfied are consumers and businesses with the outcomes? So those are just some things to think about that we want to sort of discuss with you, as well as what the speakers contribute after this session. So now we're going to actually move on to our speakers. And our first speaker, I shall hand over to Örjan.
I'm very impressed that you pronounced my name right, but you have a rehearsal, I know. I want to start with saying thank you for giving me the opportunity to tell you a little about BEUC's view on this topic. I have to say sorry for my voice because I have a very strong allergy. It's not against any one of you, it's against the trees, so don't feel offended. My name is Örjan Brinkman and I'm president of BEUC, as you've seen. I'm going to give you a picture of BEUC's view on this topic. I'm going to talk a little about solutions. Maybe I'm going to make some demands. And I know some of you have been dancing yesterday, so I will kind of invite you for a dance as the last thing. Enforcement and redress has rightly been identified as a top priority for European consumer policy. BEUC, of course, strongly supports this emphasis on enforcement. We even believe that this area will be the main subject for the future of the EU consumers policy and law. The question will no longer be how should we harmonize or what needs to be harmonized by European law. But the question will be, how do we ensure that European consumers can really benefit from their rights? How can we ensure that we did not only create a paper tiger law? How can we ensure that people feel that they are protected, that they can rely on these rights to be enforceable, that they will get compensation if something goes wrong? That is the question that we're posing. One example that is really connected to the topic we have for today is the challenges in the digital single market. I was recently in Brussels in a big event with the stakeholders, and I can assure you that there were, I think, almost 800 companies listening, trying to figure out how to work and how to do it. In particular, when it comes to the digital single market, for European consumers to engage in it, we need a strong legal framework which is respected by digital business actors, and we need realistic redress options. To illustrate it, I was going to tell you, I wanted to give you an example. Two of our member organizations, the one in France and the one in Germany, they have brought legal action against Facebook. You know Muscles? And one of the members, the Council of Norway, they are in negotiation with Facebook. The starting point is that Facebook is, as I said, a huge player in the digital environment, but according to our members' evaluation, and this is an evaluation that is supported with a lot of university studies and other things, it is in breach of many consumer and data protection law provisions. The difficulties are very big when consumers' organizations try to take actions in such a case. And why? Yeah, firstly, we can say it's because of legal uncertainty. Does European and national consumer law apply at all at these new business models, which provides services for free? But in reality, of course, it's not free because you pay with your personal data. We can also point that the EU injunction directive does not allow action on personal data protection issues. Therefore, the questions arise whether consumer organizations are allowed to take action. And also, last but not least, the complexity of the case. It takes weeks to analyze the contract's terms, which are scattered around sub-websites, and they are very unclear and typically changed by the business quite often. I think most of you have looked into these contracts. It's like, yeah, you just tick the box, but do you really read it? Consumer organizations in several countries have nevertheless decided to take up this challenge to fight against this digital market business. But is it really necessary that such case take up, and I know that some of the former speakers in the last session that we listened to also was into that, is it really necessary that the member states do this individually? I also have to ask, where are the national, and now I'm putting out my, where are the national enforcement authorities in all this? From this example, it's more than obvious that we don't have the right means in place to tackle such EU-wide infringements. And this is typical for the single market, because the digital single market is without physical borders. What we saw when we had this meeting in Brussels is also that the development of legislation and other things, I just looked at myself. If you look at yourself, when the fax machine, some of you might be as old as me, so you remember when the fax machine comes, but this has been a development, technical development with computers and everything that has been going in a very fast, and some of the legislation that we are working with is still connected to the old days. And this needs to change. Therefore, we suggest a number of solutions. We need a mix of enforcement tools We need a mix of regulatory approaches, and we need an integrated approach to enforcement. Where all stakeholders work together. And we call for the following. First of all, national enforcement systems and their cooperation on infringements must be improved. The potential of enforcement cooperation, both within member states and among them, has not been achieved until now. The Consumer Protection Cooperation Regulation has to enable more efficient targeting of cross-border infringements, and at the same time, new procedures for addressing EU-wide infringements should be established. National enforcers need to have the right resources and more investigating powers. The situation is very diverse now, especially regarding the power of on-site inspections and the level of sanctions. And second, enforcement should be linked to individual redress. For the system to be complete, national enforcers need to facilitate redress for consumers by investigating consumers' harm and ordering compensations for the victims. And third, EU-level infringements need to be addressed by specific means. Therefore, we think we need a discussion on the European Commission's enforcement powers when it comes to consumers' rights, and that it should be launched. And last but not least, of course, it's me standing here, cooperation with the consumer organization. Consumer organizations should be partners of enforcement authorities and should also be seen as such. A constructive exchange of information would be a first step. Consumers' organizations has also be able to participate in the priority setting of the enforcers and discuss concrete enforcement issues. Among other things, it should be possible for consumers' organizations to bring cases to the national enforcement authorities and ask for enforcement action. Now it's the time when I will ask you to dance. And I will not do it for real. Everyone looks like, do you go down like this? No. So after all, if I conclude, we have big challenges ahead. And as the European Commission already has a better regulation agenda, now comes the dancing. Maybe it's time to dance with a better enforcement agenda. Let's print a t-shirt, better enforcement agenda. This is what the consumer now, today, the European consumer today need most. Okay, thank you.
So thank you very much to Örjan for his perspective on the need for EU-wide enforcement, national level enforcement, and a very interesting topic for us in the UK for new powers that we're going to be having is about the enforcement linkages to individual needs for redress. We now move on to Angelo from the Commission.
Thank you. I think my intervention will probably fit nicely with the intervention of my predecessor here on the bench. A lot of speakers yesterday, today have referred to what are the main elements and novelties of the current developments when we want to address enforcement challenges in the online world. So the digital single market strategy has been mentioned. Data protection, vulnerable consumer, specific unfair practices, and also the actors involved, the national authorities, the new system of ODR, which will be launched in 2016. In this respect, let me just say that maybe one important actor of this enforcement equation has been probably not praised enough, is the European consumer centers, who make really a great job helping the enforcers, first and foremost the consumers, in their individual and daily problems, and the enforcers and the policymakers with the provision of data that they collect. We have seen this in the last joint enforcement action on car rental, the ongoing one. Now, I thought I would focus my intervention on the tools to achieve better enforcement, in particular in my sort of hat as deputy head for the enforcement unit in the Commission on the revision of the Consumer Protection Cooperation Regulation and how this revision can bring something to better enforcement in Europe, especially in the online market. And I will focus specifically on the powers of the authorities for tackling infringement of consumer law in the online markets. Now, how do I proceed? Yeah. Okay. So, the Consumer Protection Cooperation Regulation, I think everybody here knows what it is. I mean, but it's, in a nutshell, the mechanism available to national authorities to cooperate and work together to stop infringements of consumer legislation. And it covers all horizontal bodies, some sectoral bodies, all the consumer acquis, consumer passenger rights, electronic commerce, and it's very broad. Now, it's a really a key initiative in this period because, I mean, the review has been going on since 2012, so it started a while ago. But what is the novelty now? The novelty is that it is framed clearly, and there's a strong political will to frame it in the context of the digital single market strategy. So it's wanted as a main enforcement tool to enact the regulatory choices that are being made and will be made under the digital single market strategy. I'm referring to what has been mentioned yesterday and today, the simplification and modernization of rules. So the digital, in a nutshell, the digital contract proposal, remedies for defective digital contents, and probably further harmonization for remedies also for tangible goods. So on one hand, the CPC now has got a high-standing seat in this process for being the instrument which give effectiveness to the regulatory initiative under the digital single market. On the other hand, the CPC keeps its importance, a reinforced importance, I would say, in this role of tools to enforce the current consumer acquis, and especially in relation to the online practices. And here, it's clear to everybody, and I think there's unanimous consensus that if it's not modernized, reviewed, make it fit for the digital work, it will not deliver. So, one other point that I would like to raise before I go further is the fact that one of the main objectives of the CPC review is to equalize, I would say, enforcement, so to reduce fragmentation in enforcement in the internal market. This is really the internal market dimension of this initiative. Talking about the single market, we need to create equal conditions for businesses to compete, so a level playing field. And at the same time, consumers, we need to invest in consumer trust, not to encourage discrimination, inequalities of treatment. And I think the enforcement has much of a stronger role than in the past. Because if I look back 10 years ago, 15 years ago in consumer policy, a lot of effort was put in regulation. Now, I think the very positive shift is policymakers, all actors involved have understood that harmonization will not deliver if it's not accompanied by a consistent management or the enforcement in Europe. So let's just quickly refer back to the problems that we currently face and enforcers currently face. So first of all, in the public consultation we ran on this initiative and in the enforcement experience, it's quite clear that the mutual assistance mechanism is not functioning effectively. So this derives a little bit from the inequality of powers and, for example, and mainly this concerns with the fact that authorities sometimes feel they don't have the minimum powers to be able to fulfill their obligation under the regulation. Like, for example, some do not have test purchases powers or mystery shopping. And if we look at the practices online now, it's difficult to think how you can investigate if you cannot try to go through a transaction, given that also a lot of consumer rules and information requirements also apply after a transaction has taken place. The fact that in certain countries it's not possible to investigate infringements which have happened in the past, so which encourage and makes these short-term, short-lived infringements proliferate. So the hit and run sort of type of technique of many traders. And then there's this, the second problem is the need to work together better to address EU widespread infringements. And this is, I think, is one of the fundamental shifts and changes and evolutions which have happened in the CPC and in the enforcement world, is that the CPC regulation was initially fought for technically what are cross-border infringements, trader located in one country, consumer in another jurisdiction, and now it's more and more used for infringements which are widespread, so companies which implement exactly the same type of practice across the EU. When we talk about the digital world, I would say that this is global. So there's a need to improve this mechanism. And the third sort of problem area that emerged is the fact that is the lack of consistency in the market surveillance and the gathering of data on the market. So policymakers and enforcers need good data to know what the problems are. And if you think that the CPC authorities, which are competent at the member states level for the enforcement of the 18 pieces of legislation that are in the annex, are around 400. And each one of them sometimes follow different methodologies to gather the data and to report it. I mean, it makes it difficult to have consistent, statistically significant data which could help both policymaker and enforcement action. Now, the alert system is underused, and that's another problem. So the possibility to signal in a widely manner an unfair malpractice. And also the fact that there's no clear mechanism now on how other stakeholders, other actors, like can feed the system with the data. We have, for example, again, and I will say again, the ECC, which are doing an excellent job in gathering, classifying the data. We have seen this in the car rental enforcement action, which is ongoing. Now, the options, we are at the impact assessment stage now in the review of the CPC. What are the options that we are assessing? So we are basically evaluating them in a very progressive manner. So we move to a scenario where we have very limited legislative intervention to a stronger, more invasive, more significant changes, legislative changes. Now, if we start gradually, I mean, and we think about the scope of the CPC, We have clearly, for example, the issue of better defining what is an intra-community infringement. CPC regulation allows for coordinated action for widespread infringement, but I think this can be improved. If we think about some of the problems that were mentioned these days, like, for example, the geo-blocking, one possibility could be to bring Article 20 of the Services Directive under the annex of the CPC regulation. Now, we spoke about geo-blocking, and sometimes there is confusion about what it is and whether it's unfair or not, or what aspects of geo-blocking and price discrimination are unfair or not. I think the Services Directive is quite, I would say, quite clear on the principle, but further guidance is needed. But you can only have further guidance in our experience if you enforce it, because by enforcing it, you face what are the real problems, and then you can develop some criteria. We have seen this in the Unfair Commercial Practice Directive, and the process we had there, from principle-based provision to very detailed criteria that we're using now. And then we have the issue of the powers. So how can enforcement, has been said over and over, deliver if they don't have the right tools? I mean, and I will go more in details on this one later. The third point, I think, it's the role of the Commission, and here has been mentioned, and I would say the role of the Commission maybe I should have added of the Member States, because again, what we have seen is that the procedure, the way the CPC function, the way the actors interact, it can be improved. And in this, I put the role of the Commission here in the slide because I think that is particularly something in an obscure point in the regulation, which maybe needs further development. Now, if I move to the power, I think, I mean, when we are looking at the investigation powers, for example, we think, and by saying this, I think, again, there's almost unanimous consensus both from the authorities at the technical level and the stakeholders that the investigation powers need to be reinforced. This is the first important pillar. So we need to, and this, I put here a list of things we are looking into, and again, let me just say that these are options. So we are evaluating, we are assessing them. It's a very participative process, and we are consulting, well, we are working together with the Member States on this, and we are consulting regularly the stakeholders. So one important power is the power to start an investigation ex officio, for example, which does not exist in certain Member States, and which is strictly related to the market surveillance activities that I was talking about before. We have the mystery shopping powers that I mentioned earlier. And again, now I was talking with Jason just 1 minute ago, and the issue, for example, of dating sites. It's quite difficult to understand and to what are the malpractices in a certain business model if you cannot get into it and experience and make the experience. But I'm not suggesting that anybody goes on dating sites, I mean. Now, there's a power to request and obtain information from other authorities, which is something which is really weak at the moment in the CPC. There are barriers, especially in the online world, to get to know who is really the trader behind a website. It's something extremely difficult. Why? Because many authorities do not have, well, this is partly related to the fact of the delocalization of servers and traders and etc. But one important point would be to get the traders on the money. So powers to request from banks that they provide information on the financial flows, the identity of the people who are getting the money, and more than everything, the powers to gather the evidence, the digital evidence. this is something which needs to be reinforced. And I put here, this is not really a power, but I think it's strictly related, the need to have better rules also for the mutual recognition of evidence when a cooperation process and a mutual assistance stage is ongoing, so that there's no duplication of efforts. The second area, I think, is the interim measures. Okay, so again, it's about preventing more harm. It's about stopping a practice. Amongst the measures which are under evaluation is the power to freeze assets. Sometimes, you know, and here again there is a progression in the extension of the power. So we go from freezing assets, order the suspension or retention of payments by financial institutions, suspend the economic activity of the trader, and even then suspend website or, in extreme cases, the complete takedown procedure, for which there are also talks and dialogues in other groups, like with the ICANN and the domain registers. Now, the one thing I would say here, I mean, one strand of work in which we are investing, will invest in more, I think is important when we talk about mutual assistance and powers, is also taking into account the fact that most of the companies are not, or many servers are not located in Europe, and we are in a global digital environment, and therefore a big part of this work should also involve international partners. And that's why we are more and more looking more and more positive attitude to also, for example, restarting a negotiation, an agreement on cooperation in consumer matter with the US. Now, the third part is sanctions and redress. And this is probably, it's difficult to say what is the weakest part in these three areas, but I think that sanctions are really a problem. The inadequacy of sanction is a problem in Europe. I mean, a big operator with misleading advertising, they calculate in advance how much it will cost them to make a misleading advertising campaign. They factor that in, and in jurisdiction where you have, like for example in Italy, where you have quite the possibility to impose quite considerable sanctions, direct sanctions from the authority, still they are inadequate. Why? Because if a company makes 30 million with a misleading advertising, even if you fine them 2 million, I don't think the deterrence effect that we want is achieved. Like fining Apple 1 million, I think it's probably peanuts for them. Now, reputation, naming, shaming is a different story. So, on one hand, sanctions should be reinforced at national level. On the other hand, we should also envisage a coordination in how these sanctions are calculated, taking into account the type of infringements. For example, when we talk about EU-wide infringements, we should allow for the possibility to make either a collective or a concerted calculation on how we should fight the companies. Publication of decision, naming and shaming. This is also something which needs to be more articulated why? Because, well, certain authorities do not have clear power to name and shame. It's not clear when they can do it, during the investigation, after, and it's not clear what is the minimum information that the outside world need about a case, and that is worth publishing. The third point is redress. And I think this is where really Europe is lagging behind. I was in the US last year at the Federal Trade Commission, and I think on that aspect, they are quite stronger than us, because the possibility for an authority to negotiate restitution, compensation, redress, so make sure that what is being recovered illegally is given back to consumers. The possibility to negotiate schemes, compensation schemes with the traders, I think it's an excellent opportunity for an enforcer. With that, I think I'm finished. Thank you.
Okay, thank you, Angelo, for your very wide-ranging comments on the tools necessary to achieve better enforcement and the impact of the CPC review on the digital market. Also for highlighting the importance of obtaining good data and information to help enforcers do their work. And it's also very interesting to hear about the work underway to look at the importance of investigative powers. And also raising the very good question of, are sanctions always effective? And particularly your last point about redress and the sort of opportunities available in other places for the link between enforcement and redress. Okay, we now move on to Siada, who is from the European Digital Media Association.
Thank you. Thanks for the invitation for me to speak here as well. So maybe I can just introduce Adema so that you know who I actually represent. I represent the online platforms, some of which have been referred to already in the previous presentations, and I'll comment on that as well. I'd like to start the intervention just on a positive note, actually, because the title of the session might be somewhat misleading. Problematic consumer markets. Two of those words I'm not really sure we actually need to frame as such. Problematic. What are we actually talking in terms of problematic markets? Problematic markets, a marketplace has problems, be it online or offline. Are we talking about just the digital environment today? Yes, we are, because that's the most relevant to us. That's the emerging markets that we are today. But do we have to always have this underlying negativity towards the online space because it's new? Markets, that's again a very ambiguous phrase that we're using, or terminology that we're using there, because there are so many different markets that we're talking about. And I think that very often we make sweeping statements about the online markets. Are we talking about marketplaces? Are we talking about third-party selling marketplaces? Are we talking about direct marketing? What is it we're trying to address? What problems are we trying to address? And I think that if we're going to try and make concrete steps forward, we need to be a lot surer of what we're actually trying to do. The other thing that I think we need to think about is things that are already in place. Angelo mentioned the ODR and ADR that are still going to come in place. We still have to see how they're going to work. We have got starting instruments, CRD, we've got UCPD, both of which DG Justice very consequent in issuing guidelines to, and where the stakeholders are trying to input. Also, again, the Commission has been very open that they would like input from stakeholders, and we try to be as open as possible to input into the procedure. So I think we need to figure out how to capitalize on this exchange of information, especially in the online space, using the legislative framework we already have as opposed to trying to add to it. Because let's be honest, industry moves a lot faster than any legislative proposal that you might think of, even if you try to, as Örjan said, speed up the process. At this point in time, we're talking about lead times of 3 to 5 years for things to actually be in place if we look down a legislative procedure. I can't guess where industry is going to be in 5 years' time, nor in 3 years' time, frankly. So if we're going to legislate for the market of today, we can be sure that by the time things are on the ground, it'll be outdated again. We need to start thinking in a different dynamic. We need to start thinking about, for example, I'll go back to Örjan's point about in France and Germany, the consumer groups taking Facebook to on a court case. And I'm not here defending Facebook's interest because I don't work for Facebook, I work for the industry as a whole. But using your example, I would be interested to see what the outcome would be for France and Germany, where a legal process is taken, or the negotiation with Norway, in Norway, and how that would work. Because actually we see some really good outcomes in some of the stakeholder dialogues in various areas. Talk about counterfeit goods, talk about different things. Stakeholder dialogues do actually achieve results, and in a very fast developing world, that might be the best way forward. The other thing that I want to mention is we do need to remember, and I know that industry can often be pigeonholed as obviously wants to make a profit. True, that is what business is. However, our key audience is our clients, our consumers. Online, if nothing else, and I know I'm in the wrong session, but the online space has empowered the consumer more than ever before. Peer reviews, reputation is more important than ever before. If you think that when in the offline world, 50 years ago, you would go to a shop and not get a good consumer service, what are you going to do? Talk to the people around you. But that's pretty much where it stops. In the online space, first of all, there's a memory of online comments, so it's not like that just disappears. And the other thing is that the online space is so widespread, companies do take this seriously. They need to satisfy their customers. This is our raison d'être. Speed and delivery, okay. Then with regards to the CPC network, we actually believe that there's a wealth of information there. And as industry, we would be very open to try and tap into somehow having a dialogue with the network, if that would be possible. If that would be open to industry, we would be very welcoming to hear directly what the concerns are. Because I think, again, as I started from the beginning, if we can define the problems concisely and to the point, then we can address them. What we can't do is have very lofty statements about what we're trying to achieve without really figuring out what we're trying to tackle. With regards to enforcement and redress, I think that there we need to look at who is it that we're trying to actually aim at there. If you look at, and I'm going to use the online marketplace as an example, is it the intermediary's responsibility to have to deal with redress mechanisms, or is it the actual third-party seller in some cases? We need to be able to figure out who the parties are that are involved in redress procedures, and once we know that, then we know how to actually deal with it. I think I wrote a few notes as well about the presentations that were given so far, and with regards to sanctions, I actually agree with Angelo on his point that some sanctions might not be effective. I don't think that Apple would necessarily say, well, we're happy to pay €1 million for no reason. No, I think they feel the hit, but I think the more important thing is the reputational issue. I think that the fact that the signal that is made through the sanctions or through the actual action that is taken by against the company, or even just the complaints against the company, that impacts the companies much more than you could imagine in terms of the financial number of or the financial amount of a sanction. Yeah, I'm sorry, I'm just trying to refer to a few of the things. And then to end on a positive note as well, the better enforcement agenda that Örjan mentioned, I can't agree more. I think actually before we start thinking about what else can we add on, let's make sure that we use what we have as tools today in the best possible way, and I think we're very far from that. So I'll leave it there because I'd like to have the interaction more, and I look forward to the questions and answers. Thank you.
Okay, thank you very much, Siada, for highlighting the importance of how consumers now have much more opportunities to tell traders what they think of them. Hopefully that's seen as a positive step. and the need for clarification in redress, who's responsible, and also about highlighting the reputational issues facing companies, and are the sanctions also effective in that area. Okay, so now it's over to you for questions and any comments. Okay, I think the...
Should we see
sorry?
who... If you've got a comment that you'd like to make, perhaps you put your hand up and we can see how many we've got, because we're probably pressed for time. There's 1, 2, 3, 4, 5, 6.
Oh, goodness me. Right, we need
We've got 6, right? So there are 6 comments that need to be made, so the microphone's there. So if we can keep each one of them succinct.
Yeah, well, I mean, we're supposed to discuss here, so I think we should stop now having these monologues all day long. So anyway, so we have a bit of time, otherwise really is a worthless conference. Sorry to say this. Bob Schmitz from the Luxembourg Consumer Union. There are many others. I'm going to make only 2 comments. Firstly, Angela, I must say, I think this is really what you just present. If you work along these lines for the CPC, it's completely unrealistic. It's completely unrealistic. There's no way that you have, even in my country, Luxembourg, that you will any chance, even if you would go through, to get this through our Council of State, etc. Don't forget that currently we have not even harmonization on sanctions, except here and there on one specific provision. We are here in procedure law and sanctions. So I think, therefore, we should be realistic. And I, again, say what I said before, and I believe really, and I actually agree with Edima on this, it's bottom up. We should really more, and that's when, I mean, for instance, and I say it again, was saying the good experience learned from the European Competition Network. On DG Competition, you find, I think, 3 or 4 times a year, there's a newsletter which actually reports also major decisions, case law, taken by national authorities. And I go on this, and you click on, and you find actually inspiration to see what my friends in Italy have done, and then I see, for instance, or anywhere else, and then I can see to what extent I can use it in Luxembourg. And so really bottom up. I think that's really where we should. And the problem is to find out about this. I give only 2 examples, of course, and somebody said it, we should go for coherence. Currently there's something on the online digital where there are 2 completely incoherent decisions have been taken in Italy and in Germany. And it concerns the liability of the hotel platforms for bookings. TripAdvisor, it's now in front of the courts, our friends in Italy took quite a harsh decision for the liability for the platform. In Germany, just right now, the Supreme Court decided in the case actually that the platform is neutral, has a very limited liability. So these are things which happen right now in the digital world. I happen personally to know this because I read Italian, I read German, I have my own sources of information. But, you know, someday I won't be around any longer, and anyway, I'm a lonely fighter. So we should get organized, and that's my final point. We must, like in the competition network, make sure that we get relevant information from this kind of private or public enforcement cases to the European level, and then to finish with a positive note, Edima, something which wasn't said, I also very much believe in promoting the front-runner best practice approach. Like, for instance, Apple was condemned in Italy. We in Luxembourg managed, because of Italy, to have an amicable settlement with Apple because their reputation was at stake. So really front-runner, I very much believe in the competition angle, the front-runner, the visibility, the good reputation too. Sorry, that was a bit long. Could say much more, but I mean anyway.
From this side now, otherwise it'll just all be too skewed.
Yes, good morning. Monique Goyens from BEUC. Of course, I will not ask my president any question. There are a lot of challenges that have already been identified, a very interesting discussion. Can I just add another layer of complexity and ask a question about whether the CPC network has also considered already extraterritorial cooperation? Because there are, of course, the digital markets don't stop at the European borders. And is this dimension also built into your reflections, or is this even more complicated and cannot really be tackled at this stage, even though speaking about not being able to keep pace with developments, extraterritoriality will certainly be a huge problem when it comes to consumer enforcement. Thank you.
side of the room now.
Thank you. Andrejs Vanaks from Latvian National Association for Consumer Protection. And of course my question relates to a role of consumer organization, which was highlighted both today and yesterday several times by several speakers. And the point I wanted to stress is that the situation for consumer organizations in different member states is actually different, drastically different sometimes. And at the same time, consumer organizations are very important players. They can help public authorities very much. And this essentially creates, these differences in member states actually create this uneven, oh, very nice, it works now, this an uneven, play field. And an even play field for consumers, for their involvement in different activities. I think redress is what everybody thinks it's very well can be addressed by consumer organizations, or naming and shaming schemes, I would say, for myself. And my question is basically on the thoughts of the panel. What panel thinks of the European level activities to somehow strengthen consumer movement, to make it more, I would say, even throughout all the member states, which I think could be of a great help for consumers and would contribute to efficiency of enforcement policies. Thank you.
Okay, thank you. I think if we can do all the questions and then come back to the panel, I think that's probably best. So, shall we go to this side of the room again?
Thank you very much. Teresa Moreira, I spoke earlier on the issue of the CPC review. I wonder if I could ask the European Commission representative to expand a little bit on the redress part, because I also mentioned that very briefly, but since you had that highlighted in your slide, if you could share with us what are you thinking about right now? Thank you.
Okay, we'll finish the questions and then we'll come back. And this side of the room, there's another one, I think.
Hello, my name is Örjan. I'm working for the European Consumer Center Austria, and my question goes to Angelo regarding Article 20, Paragraph 2 of the Services Directive. We in the European Consumer Center network and in Austria, we have a lot of cases of discrimination based on the place of residence. Consumers who want to shop cross-border are often told by the traders that it's not possible due to their place of residence. The problem in this issue is that enforcement currently is not working at all. Like, for example, in Austria, the enforcement is the task of the regional administrative authorities. They can find sanctions up to 3,000 euros, and it's an administrative procedure, a penalty procedure, so it's not working very good. So my question is, will Article 20, Paragraph 2 be included in the CPC regulation in future? And another problem I see is the provision itself is quite legal unclear. There are a lot of legal uncertainties with this provision regarding objective reasons or other questions. So, like, traders often bring reasons where we think it's the question whether it's objective or not. So my question is, or my point I want to make is, on the one hand it's enforcement, but on the other hand we also need legal clarity from the courts, court proceedings, the Court of the Justice of the European Union, to get clarity. So enforcement, but also court decisions, I think. So, sorry, I was quite in a specific area now with Article 22, but it was mentioned by Angela, so I wanted to ask you, will it be included in the CPC regulation? That was my question.
Thank you. And was there another comment over here? Yeah.
Yes, Jens Henriksson from the Swedish Consumers Association. There has been a lot of discussion in relation to new markets, and often that is referred to then really new markets if it's in relation to Apple or it's in relation to these big, often American companies and so on. But I think new markets is very much about the small nitty-gritty details in the society, in terms of the way you make your booking in your healthcare system, or the way you buy your public transport tickets, or the way you buy tickets for events or whatever, things that has worked perfectly well in the old traditional society with the existing rules. And for me, it's even more interesting with the consumer problems that are there in areas which used to work perfectly fine, and now with a lot of big vulnerable groups in society not being able to access all the very many good things with the new business models. But I think it's one of the worst situations is when consumer had markets that worked quite well and introducing new concepts in terms of being digital and not working at all. And for me, the CPC network and all people that work on consumer protection should really focus mostly on the things that worked very well, but then with new digital techniques has been a huge problem for a lot of consumers.
Maybe there's an issue about how you define what a problem is, because probably those things work very well for many people, but not for perhaps the digitally excluded. Was there a question over here, a comment? Yeah.
Thank you. Angelo, you have very well described how the CPC mechanism actually is, let's say, a 2-horsepower small engine. It runs, but not very smoothly and not very performant as one would think in this age. So I totally agree with your analysis and the elements that you put forward to make the mechanism better and smoother and performing better. They are very valuable. They may not be complete, but they are very valuable. But one thing is missing. It will also need fuel. Currently in the CPC regulation, it is foreseen that member states should provide sufficient resources to make the CPC regulation work. Apparently, such a provision is not sufficient to make it actually happen. So something will have to be defined in terms of resources, and not only a quantity of personnel, but also skills are involved. The thing is with CPC that it's very difficult or even impossible to plan what it will cost you. Some member state or some authority establishes an infringement, finds out about a problem, issues a request, and actually kidnaps the capacity of another member state who is not expecting that. And actually that member state should be able to mobilize very quickly a capacity to respond to these requests. This is a very difficult issue to treat. And another remark, more general, is I think you will need a lot of details in new provision and revision. When you say obtain information from anybody, also third parties, example giving banks, I think the example given should be in the regulation, because member states will implement it without the banks, because banks are very powerful. It's just an example. It should be, let's say, formulated in terms of results, in terms of what it should be able to do. I'm thinking about the issue, about the topic of sanctions. If we would be able to have an equal framework for sanctions, but in the member states it's still subject to deficient justice systems, and we know there are some deficient justice systems in the member states, we're not any further. Because the sanction will be there on paper, but in practice it will still be, as Sir said, a paper tiger. Thank you.
Okay, thank you. So just to draw some of these thoughts together then, before the panel respond, I think we've got some themes about the law, right? We've thought quite a lot about the law. What does the law mean? Platform liability, extraterritorial effect. There's issues about Article 22, I think, isn't it? It's the Services Directive, 22, yeah, of the Services Directive. You know, so that's one block of issues. What does the law mean? Can it be clarified? There's issues about powers. Do we have enough powers? And then there's issues about enforcement attitude. And I think that came out quite a lot in the presentations and also in some of the responses. Enforcement attitude. So you can have the powers, but if you're not willing to use them, or you're difficult and you don't want to see businesses as committing infringements, which I think may be the case in some member states, then you're not going to use your powers. And similarly, if you're not willing to cooperate with consumer organisations, you're not going to do that, even if there's a framework in place to do so. So maybe those are some themes. We haven't really discussed much about problematic markets or problems in markets. There hasn't been much discussion around that. I was thinking that possibly in the light of the comments about the sharing economy, that may be a fruitful topic for some brief discussion. What should the legal framework be in the sharing economy? There's many problems which exist to do with platforms. There's also problems where traders are operating, perhaps pretending to be consumers. And then, of course, there's the issue of, or indeed they may inadvertently become a trader, a consumer may inadvertently become a trader. And then there's issues of consumer responsibility. Is this worth a further discussion as an emerging topic, or do you think it's a waste of time? Let's have a vote. Who thinks we should have a discussion about it? Who thinks it's a waste of time? 5 minutes. All right, so we can have a very brief and succinct point. Who would like to make a point about the sharing economy and where the balance of responsibility should lie? Anyone? Go on, then.
As my Swedish colleague said, we should firstly see how the digital world is actually making life difficult for what worked in the past. And currently, we have sufficient services and goods which are offered online. And the best example is the click-through, and those of you who know the current impossible outcome of the package travel directive. The liabilities of something which is close to the heart of consumers is travel services, the liability. So why the hell should we now discuss something when I think about the shared economy and so forth? We are actually missing out the whole thing of the liability of platforms. We mentioned one like the TripAdvisor. This is the stuff which is right now on the market. While other, I don't understand the way these discussions go. Sorry.
All right, thank you. So I think the point, if I can put it in as neutral a way as I can, I think the issue there is about platform liability. And I think the comment is that platform liability in the internet space remains a pressing issue which is unresolved. And that, I think, will be the case in the sharing economy as well. The role of the platform is important, and it's important we get the law straight. Go on, then.
That it is an issue that we need to look at, and as platforms we've always said we're open to having this discussion, but it has to be a realistic discussion in terms of we have the e-commerce directive, which was a viable framework for a very long time. We need to then see what is it that we're trying to address, and we do need to, I started out with my intervention with define the problems, define the actors, and I think that that's what we need to be doing, because at the moment what we're doing is we're saying we're only going to be talking about a few pillars that we have to address, we're only going to be talking a few, but there's such huge areas that we're looking at, we're not looking at specificities, and that's where we as industry have an issue as well. We're open to have the discussions, but define the problem, define the issue we're trying to tackle, and let's try and sort out what we're trying to achieve, as opposed to having very big sweeping statements and frankly acting as political actors at this stage, because we have to be more pragmatic.
So I think just on that, to briefly define the problem, as I see it as an enforcer, I think the problem is the definition of a mere host. I think many businesses seek to hide behind, and I say that perhaps provocatively, the definition of mere host when they're not performing a mere hosting role. They're performing an active advertising role, they frame the results, they shape the results that you see, they'll perhaps give advice to traders, they share in the revenue, all of those things. Those are not the things that a mere host would do, they're things which a trader would do. And so I think the issue for me, anyway, and maybe others in the room may agree or disagree, is whether a platform should be defined as a trader under the Unfair Commercial Practices Directive and subject to all of the requirements of that, or if they still get to have a get-out, as it were, as a mere host, and what that actually means. Yes.
And there my response would be, which platform are you actually talking about? Because we have a lot of case law from national courts as well as from the European courts that have had results on that. But I think that, again, if we're going to try and entrench that in some form of legislation, then we need to be more precise as to what we're looking at.
Okay. Thank you. Were there any further comments on that area? Yeah.
Is the work we are doing on the guidance, the UCPD guidance. I mean, I'm a little bit more positive than Bob on this, because I see the criticity and the problem there, but I mean, I also see some good case law developing in the member states. And yeah, the issue of sometimes a court or an authority slightly deviating, and I still think what the German court outcomes, it still needs to be clarified, what it really means. It happens at the European level, it happens also at the national level. You never have, you have the independence of the court, you never have 100% uniform outcome in the enforcement action. But again, I agree in a sense with Jason, we are talking about the law. We are talking about the criteria here. And let me say, it's an area that we never underestimated, and we always worked quite hard on this one. With the previous guidance, now with the new upcoming guidance, this is really the main part, and let me just be more precise. I'm in favor, when I hear about defining business models and etc., I'm more favorable to an horizontal approach to online intermediaries. So I hear what intermediaries, what business models. I hear you, Bob, saying it's a trader or it's a seller. I think what the online world, in my understanding, is showing us, it's a very rapid evolution, and it's also a convergence of practices. So now the business models are very similar in the sense that the revenue stream comes from advertising, comes from very clear, now clear, already 1 year ago and 2 years ago they weren't that clear, system of financing, so-called free models, which in reality then, again, part of the thinking now is how to accept that they are free, or maybe they are not so free, or the value to be given to consumer profiling not only just what are technically personal data, but also my preferences, my behavior on the internet, the cookies. I mean, we have already quite a good debate ongoing. So I'm in favor of a horizontal approach. I think there should be principles which are applicable to all online, let's call them operators, depending on what type of activity they are engaging to. So when we're thinking about reviews, consumer reviews and the user reviews for advertising, I think we should have clear principle on that. When we are thinking about comparing services, and most of sellers or booking websites you're referring to, they also compare. So I think, again, there's an interesting work which is ongoing with the member states, with the stakeholders on the UCPD guidance. And, but we are talking about the law. We are not talking about the tools.
Okay. Were there any other comments that anybody wanted to make, or reflections on the discussion so far? Oh, there we go, stunned silence, that's it. So I think there were just a couple of follow-up points. Mainly, I think, for Angelo, and on redress and on the services directive, if you'd like to address those briefly.
If I may, I will just also follow up a little bit what Bob said earlier, and I think Bob and I share the same objectives, and sometimes we have different ideas of how to achieve them, but let me just say that what I presented are just options, okay? So, again, there should be clarity on the fact that we are assessing, we are evaluating what is worth. Still, I think we need to be a little bit braver when we talk about enforcement, because, nobody here wants to or intends to, not even thinking about harmonizing enforcement. Enforcement is a member state competence. However, we have seen clearly that member states cannot just go solo on these matters, because then the action is completely inconsistent and it doesn't achieve what we want to achieve. So, having said this, I would like to address the question on extraterritorial cooperation. As I said before, we really believe is important to work with international partners, and I'm referring in particular to the US. So within the CPC work, we are moving, I think, in big steps towards reopening a negotiation of an agreement on consumer protection cooperation with the US. There were negotiations already in 2012, 2011, 2012. They were interrupted because of data privacy concerns in the transfer of data and the cooperation, the transatlantic cooperation. Now these have been arguably solved through the work which is ongoing in the data protection area, so the negotiation of a data protection agreement, so the enforcement of the commercial agreements, the safe harbor with the United States, and we can mutuate good solutions that have been found there. So I think it's an important part of the work, and we will work on that. Concerning redress, what I meant is really making sure that at least what has been illegally recovered, or what has been perceived by a business using an unfair practice, can be then recovered and given back to consumers. That's the idea. And the model I have in mind at the moment is, for example, the US model, where the agency sits with the company and agrees on an amount of money which could possibly accommodate. But again, that's a negotiation process. We don't have to go that way. We are in Europe. We have different also system with a different way of working. But I think that whatever is the solution, I think a company cannot just sit and run away with what has been earned through an unfair practice. I think that's a problem that we need to solve. And we need to be able to provide for schemes, compensation schemes, whereby a trader set up, a mailbox, an office, in the aftermath of a case, to give back, to reimburse consumers. I think that's an important part. The Services Directive. Again, when we talk about geo-blocking, price discrimination, I think it should be clear that businesses should not be obliged to engage in cross-border trade. They should not be obliged to deliver in a different country. I still think that's really, it's too much intertwined with the freedom of business and freedom of set business models. Now, when we talk about price discrimination, the Service Directive, we talk about unjustified price discrimination. We have legislation like in the air sector, the air transport sector, the air passenger regulation, which prohibits altogether discriminating in between depending on the place of residence of the consumer. We have the Services Directive, which prohibits unjustified discrimination. Now, again, that article, there's a wide consensus that the article is not currently being enforced. So nobody is doing anything about this. And so that's where the idea comes to evaluate, to assess whether it could be feasible to insert it in the annex of the CPC regulation. Although, I mean, it depends also what we want to achieve in this. And part of it will come from the real application. So once we start enforcing the article, we'll understand what the jurisprudence will develop, best practices in enforcement will develop, business models sometimes adapt to it. So I think it's a gradual process. Is there anything else?
Okay. No, I think that was it. I mean, on the extraterritoriality thing, one of the things that interests me is whether directives protect US consumers. Right? So if a US consumer feels they've been misled by a British business, let's say, can we do something about that? Does anyone know the answer to that question? Do directives have extraterritorial effects so that they provide protection to overseas consumers? They don't. Should we have a vote? Who thinks they provide no protection at all? You can put your hand up. No protection? Anyone else think no protection? Who thinks it does provide protection? Yes, one lonely voice?
Well, if they use the contract terms, I mean, they can use the...
I'm thinking about whether we can get an injunction or an order or fine an EU-based business who has been misleading US consumers. Right? They've infringed EU law, so they would have committed an offence, or they would have infringed the directives had they been acting solely within the EU. But because some of the consumers, or one of the consumers, or all of the consumers, is outside the EU, can we do anything about it?
Well, I think, I mean, firstly, I mean, in this case, the company, the defendant is a EU-based company, okay?
Yep.
So normally, I mean, if a US consumer would sue in front of a, normally
I'm
it's...
not talking about the US consumer suing, it's us, the enforcement authority.
Are you?
Yeah, the enforcement authority getting an order to stop what would be illegal practices, clearly illegal practices, taking place within the EU by an EU-based trader, but directed towards non-EU consumers. This is the issue. Because if we can't do that, we've got a problem, haven't we? Because when we ask the Americans, can you stop one of your companies from misleading us, they're going to say, why should we?
Can I give one example? And it is actually one which was currently in front of the German court again. It is indeed, if we take the e-commerce directive, because the e-commerce directive, as we know, is the one which enshrines the principle of the country of origins, the control of the authorities and the law of the trader's country. And in that case, the case concerns WhatsApp, US Californian-based company. And the German court, I think, rightly rules that actually the e-commerce directive only applies to EU-based companies, because to justify the application of the country of origin, so the home principle, it actually presupposes that at least there's a sufficient coordination of the substantive laws which are in place, and that only it prevails within Europe. So if you take that one, which normally is, I think, the best piece of law, because normally it's the authorities, in this case, of where the EU traders are established, you couldn't even use that one if they misbehave outside the EU, in my view.
But presumably, on the country of origin principle, they have to comply with their own law. So then we could use it. We can enforce, can't we then? We finally found a use for the e-commerce directive.
If you, Jason, to respond to your question, I mean, in the US they have the Safe Web Act, which allows for the US authorities to take enforcement action to protect foreign consumers under certain conditions. So one of the reasons why they've been pushing a lot for us to sit and restart negotiation of a cooperation agreement, because they see that on their side they've done their homeworks, and on our side maybe we can go a step further. Yeah. Now, I don't clearly see a limitation in enforcement at the EU level. If we want to see it, we see it. If we don't want to see it, we don't see it. It depends a little bit. I mean, that's why, I mean, there's not written anywhere, I mean, that only EU citizens are protected, or that a company, as long as they scam people outside the EU, they are free to do so. I'm not sure about this.
Maybe you should clarify it then. Go on. Yeah.
Yeah? Okay. I think the country of origin principle would prevail in that case. The only thing is, what would the redress mechanism be for the US consumer in this case to actually get their rights? I think that would be where we would have to look as to what avenues would they use to get their representation, because country of origin would prevail then in terms of what the trader would have to comply with.
So presumably if we do have some kind of decent redress system in the EU, it should extend to overseas consumers as well, non-EU based consumers. It should be explicit. on the legislation, so there's no doubt, because otherwise there will be a problem, I think. Ideally. All right, are there any other comments or follow-up questions? We've taken the liberty when we were preparing this feedback session to do some slides, which we thought we predicted would form the, summarize the debate. They've broadly done so. There was less discussion on the sharing economy than I'd have liked, so apologies for the slide on the sharing economy. And there's a few other bits that I'll add in, but I thought it's easier to have some slides that people can see rather than just hear me whittering away. So thank you very much for your participation. I think we'll wrap up, and thank you to the panel.